and get started, given that we are incredibly privileged to have with us here today Darius Charney, who is a senior staff attorney at the Center for Constitutional Rights, or CCR, in New York. We're very grateful to have Darius here today, including because he had to reschedule, given sort of demonic snowstorm in New York City a few weeks ago. And so thank you again, Darius, for your flexibility in that. We are very grateful that you're here. Darius will talk to us today about lawyering for racial justice. And so really thinking through what are the different legal strategies that can be pursued in seeking to have accountability around racial injustice, but also how the law interacts with social movements and other strategies that we utilize as lawyers when we think about bringing about change to mass racial inequality. The event is the final, which is very hard to believe, final event in our Human Rights in Practice series, a series coordinated by my colleague, Professor Fanfalo. And so again, that's another reason why we're very grateful to have you here. The practice series is co-sponsored by the International Human Rights Clinic. I should mention that I direct, my name is Jane Huckabee, but it's also organised in collaboration with the Centre for International Comparative Law, and we're very happy to have Professor Helfer here, who is one of the co-directors of that centre. In addition to this particular event, we have co-sponsors, including the Black Law Students Association, the Duke Human Rights Centre at the Franklin Humanities Institute, the Duke Human Rights Centre at the Keene Institute for Ethics, International Law Society, and the Human Rights Law Society. And with that, I'm going to hand over to Darius, who will speak and make a presentation, and then we'll open up for hopefully an interactive and robust Q&A. Thank you, Darius.
Thank you so much for having me. I'm very pleased to be here. I am actually a undergraduate alumnus of this fine institution, class of 1995, so go Blue Devils. So as the professor mentioned, I'm going to talk to you guys a little bit about lawyering for racial justice, particularly how we at CCR do it, which you may, through my remarks and the Q&A, find out is similar, but in some ways different than some of the other civil rights organizations may do this kind of work. Obviously, this is work that is done by a lot of fantastic lawyers around the country and the world, but we all, I think, bring our own kind of approach to it, and we learn from each other and collaborate, and hopefully through this discussion we can see some of the ways that we do it at CCR and how you guys think about doing it. You get into your legal careers. So, actually, let me go back one photo. So the reason I chose this photo to start with is because this, I'm sure everybody recognizes many of the people in these photos, but these photos, I think actually, if you think about the time when they were taken, really span the history of CCR. We were founded in the mid-'60s, specifically representing civil rights activists in the American South. And throughout our history, we have continued to work very closely with folks on the ground doing work in the area of racial justice, both here in the South and around the country, and in some cases around the world. And so I think this captures, in many ways, our historical commitment to these issues. Everybody, I'm assuming in this room, knows the legendary Elle Baker. We at CCR have had a very long and close relationship with her during her lifetime. This quote, I think, also is something that I really think about a lot when I do my work. And I think the reason this quote means a lot to me as a civil rights lawyer, as a human rights lawyer, is I think similar to civil rights leadership in terms of like thinking about not only the folks who are interested in being leaders of a movement, but developing leadership in others. I think as lawyers, one thing that we need to think about is that what the movement needs most is not necessarily lawyers who are going to take charge of the movement or try to lead it in a particular way, but we need lawyers who are going to help develop the folks in the movement to do what I think is the real work. Things to keep in mind, I think, as you think about lawyering around issues of racial justice are, first of all, litigation is a complement to and can really never be a substitute for the grassroots organizing, the education, the legislative and other strategies, which in our view is really where the real work happens, where the real change happens. And similarly, even when you do talk about litigation, lawyers don't have all the answers. And I'm going to give you a specific example of that in a couple minutes to show you why that is true, or why that can be an issue if we don't remember that. Another thing which I think is not news to anybody, courts are conservative, and by that I don't necessarily mean ideologically, although of course I think in the United States they tend to be ideologically conservative. They are very conservative in the way they view their role, I think, in kind of bringing about change or bringing about political, economic, social change, and they view their mandate and their authority very conservatively. And I think that becomes an issue because when we're talking about the issues around racial injustice, we're talking about very systemic, deep-seated, long-standing issues, and that are going to require really profound changes. And that's really where courts not only are not that necessarily equipped to do it, but are very hesitant to go to those lengths. And then the importance of history, and I think that again will become clear. I'm sure already clear to many of you, but it will become clear as I talk through some of the examples of the cases and projects we've worked on that we definitely not only have to learn from history and learn from our mistakes and our past work, but actually in the way that we discuss the issues and the narrative and developing the narrative and changing the narrative, I think history becomes a very important tool and an important part of that project. And then lastly, I think we as racial justice lawyers have to always remember and think about is, does the litigation or the legal work we're doing help impacted communities build power? And that's, I think, goes back again to the Ella Baker quote that I think the goal is not for us to lead the movement, it's for us to create the space to allow others to lead the movement, the folks on the ground, because they're the ones who are going to do the real work and I think bring about the real change. And so when we talk about power and building power amongst grassroots groups, directly impacted communities, we, I think as lawyers, should think about it in three kind of buckets, pillars, if you will. One being the pillar of policy, another the pillar of consciousness, and the third the pillar of service. And I'm going to give you a specific example in a couple minutes of how that was applied in a case project that we worked up in New York City around the police department there. But pillar of policy is obviously has to do with bringing about policy changes. Pillar of consciousness, I think, goes to this issue I was talking about before around the narrative, the story, taking control of the narrative and how the issue or the problem gets discussed. And of course, I think very often the people most directly impacted are not the ones who are controlling the narrative. And so figuring out a way to help them take control of that narrative and give them the ability to do that. And then lastly, the pillar of service. I think as lawyers, we need to always remember first and foremost that we are providing legal services to our clients, whether that's a grassroots organization or an individual. And so we always have to keep in mind that what we are trying to do is what our clients need and what they want, even if we might have a different idea about what that would be. And that if you're working on all three of these pillars and keeping these in mind, the goal would be if you're advancing each of these pillars, you will also be building power amongst the directly impacted folks around whatever issue it is you're working on. A couple early examples, I'm not going to talk too much about these, but you can read more about them on our website. When I mentioned earlier that CCR's work in this area goes back to literally our founding, that is literally true. 1966 was when CCR was founded. That is also the year that the case Hamer versus Campbell, and obviously Hamer is the legendary Fannie Lou Hamer. It was one of the first cases, federal court cases, which applied the Voting Rights Act. I think this was the Fifth Circuit case in 1966. That was a CCR case. North Carolina versus Joanne Little. Do folks know this case? I found that a lot of people don't know it. Yeah, so it's a really important and really fascinating and fantastic case involving African-American woman Joanne Little, who was arrested out in, I think, Beaufort County, North Carolina in the early 1970s. And while she was in jail awaiting trial, she was the prison guard and the jail guard attempted to sexually assault her while she was in jail. She stabbed him in self-defense, killing him, and was charged with murder for that. And CCR co-counseled with some local attorneys. We were able to get the venue changed from Beaufort County to, I believe, Raleigh County, if I'm not mistaken, to get a much less racist jury, to be frank. Ultimately, Ms. Little was acquitted, but beyond that, the reason I think this case is very fascinating is the movement that built up around it. And it really is a movement that's very connected to, I think, the history of particularly black women going back to slavery and Jim Crow, combating and resisting sexual violence. And there was a direct link between the case and the way the case was talked about and really all of that organizing, which goes back decades, if not centuries. And so, again, this was a case which CCR obviously was a legal case, a criminal defense case, but thinking about how to connect it to the larger movement was something that was really happened from the beginning, and I think is in no small part contributed to the ultimately successful legal outcome. Daniels versus City of New York is a case which I came in on the end of it because it really went on for about 8 years. But this is really the beginning of CCR's work in New York around the stop and frisk issue. 1999 was the year that Amadou Diallo was shot by the NYPD. I don't know if folks, some of you are probably too young to remember that. But Mr. Diallo was a immigrant from, I believe, Guinea in West Africa. He was a street vendor. He lived in the Bronx in New York City, and in February of 1999, coming home from work late one night, he was shot 41 times by New York City police officers, plainclothes police officers. He was unarmed. They shot at him when he was entering his building, and they told him to freeze, and they said, turn around. He did so. He held his hands up. He was holding his wallet in his hand, and the police, they say, mistook that for a gun, shot him 41 times. Obviously, there was a huge outrage, not only in New York, but really around the world from this tragic incident. And a lot of the police accountability groups in New York who have been working on these issues going back into the 1980s met at CCR, I believe it was about a week after Mr. Diallo was killed, and CCR lawyers were there, and there was a discussion about what could be done really to address what was really a systemic issue, which was racially biased, brutalized policing of communities of color in New York that had really been going on, obviously in some form or another for forever, but particularly in the 1990s when you saw the explosion of zero-tolerance policing. That was when Rudolph Giuliani and Bill Bratton came into power and really decided that they were going to aggressively and proactively, as they said, police communities of color in the city. And this, what happened to Mr. Diallo was really was a natural result and tragic result of that. And so the discussion was really, so we want to really go to the root of the problem here. And so what was decided on was that there was going to be a class action lawsuit, this case, filed on behalf of several of these groups and individual members of these groups who had been stopped and frisked repeatedly by the same police officers, the same unit of the police department that killed Mr. Diallo. It was a street crimes unit, which had been around since the 1970s, and was, by that point, notorious for being just incredibly aggressive and abusive in black and brown communities in the city. And so this lawsuit was going to challenge their stop, push, and frisk practices under both the 4th and the 14th Amendments, alleging that they were stopping people without reasonable suspicion, which is the standard under the 4th Amendment, which permits it under the Terry case, and that also it was being done in a racially biased way and therefore violated the Equal Protection Clause. The case, as many federal lawsuits tend to do, went on for several years, dragged on, one would say. And of course, during the time that it was proceeding through the court, 9/11 happens, and I think that had a very significant impact on the police accountability movement, both in New York City and really nationally, because I think that's a place where the narrative around law enforcement, police, liberty, security, the narrative changed. And so that happened in 2001. I think, there was also obviously a lot of abuses in terms of what was being done, particularly to the Muslim South Asian Arab community, and so a lot of folks' attention and efforts were being diverted that way. And so, unfortunately, in the early 2000s, you saw kind of an ebbing of momentum when it came to issues around racial profiling, particularly Black and Latino folks, and the stop and frisk issue. There was kind of a loss of momentum in the grassroots police accountability community in New York. But that was a problem when we talked about the litigation because whereas when the case started, we had NCPR, which is the National Congress of Puerto Rican Rights. That gentleman in the picture, Richie Perez, was the founder of that organization. They were initially one of the organizational plaintiffs. They dropped out of the case. The kind of communication line between the lawyers and the grassroots folks really kind of fell apart a little bit for a variety of reasons. And so what ended up happening is by the time we get to 2003 and the city finally says, okay, we're open to talking about how to settle this case, how to resolve it, the grassroots folks did not have a seat at the table. You just had a kind of a traditional settlement negotiation between lawyers and lawyers for the plaintiffs and city lawyers. And so what you ended up with is a settlement that, because it was negotiated only by lawyers, was very limited in scope and really was just about changing things on paper. They had to, this picture here, they had to actually write a department policy regarding racial profiling. The policy did prohibit racial profiling, but it was very, cursory, very superficial, didn't really say anything other than you can't stop somebody solely on the basis of race. There were really no procedures for how they were going to monitor this or monitor compliance or make sure it wasn't happening. And so what you end up with is over the next 4 years, because the settlement was in place for 4 years, is I'll go to that second. You have an explosion of stop and frisk in New York. From 2002 until 2006, I think the number of stops increases about 500%. The racial disparities continue to be extremely severe. More than 85% of all the people stopped are Black and Latino, and this is in a city where those two groups make up about 50% of the population. 90% of the stops don't uncover any evidence of criminal activity. Only about 1% of the stops find a weapon, which is the only purpose of a frisk is to search for weapons, and they're only finding weapons in 1% of the stops. So what ends up happening is that by 2008, CCR, again consulting with some of our colleagues in the police accountability movement, say, well, what should we do? Because the settlement didn't change anything. And they said, well, can we bring a new lawsuit? And that's actually what we did, which is the Floyd case, which some of you may be familiar with. In my understanding, it's read in law schools, which is kind of cool. But this case really expanded on the Daniels case because now instead of challenging the stop and frisk practices of one particular unit in the police department, we challenged the practices of the entire department. Because by that point it was clear that this was a citywide problem, it was a department-wide problem, it was getting worse. And like Daniels, the case really built on the grassroots organizing that had been going on around these issues for many, many years. And by this point, 2008, 2009, that ebb I was talking about earlier was kind of coming back up. You had many of the groups that had been involved in the movement since the 80s were kind of regularly meeting again. CCR was going to those meetings too. And so we really felt like it was the right time to really push this forward again, and this time in partnership with our partners and colleagues in the grassroots police accountability movement in New York City. The plaintiffs we had 4 named plaintiffs. 2 of the 4 were individual members of these organizations, including the gentleman there, the lead plaintiff, David Floyd, who was a member of the Malcolm X grassroots movement, which is it's a national organization, but the New York City chapter had been involved in these issues really going back to the mid-1980s. And we also had 2 non-activist New Yorkers of color who themselves have been repeatedly stopped and frisked and decided to get involved in this case because they didn't want this to happen not only to them but to their family and friends anymore, and they wanted to see change. The case was really about injunctive relief. There were no damage claims on behalf of the class. And unlike the Daniels case, this time we made a very concerted effort to try to work with our partners in the grassroots community to make the litigation an organizing hook for our allies that would support the work they were doing. Now, as with any case or project that really involves structural institutional racism, you're dealing with a powerful adversary. And in this case, the NYPD, I think, was about as powerful as they come when it comes to police agencies. Broken windows is really the dominant policing philosophy in the United States, if not the world, by this point, 2008. And it really started, for all intents and purposes, in New York City, at least on a kind of a systemic level. It's a police department that has a multi-billion-dollar budget, has very powerful allies in all levels of government, and even this is the Obama administration that this case really was litigated under, and very many powerful allies in the Obama administration, and a really ruthlessly effective media machine. They even had their own newspaper, which is known as the New York Post. If you read the op-ed page of the New York Post, you will never see a op-ed that is ever critical of the New York Police Department. You will see repeated op-eds that are incredibly effusively praising, but never the other way. And the flip side is there are many articles not only demonizing, civil rights activists, but really demonizing people of color. And I like to say the only time you're going to see a person of color on the cover of the New York Post is if they've done something illegal or there's some scandal. You're never going to see positive coverage of those communities. So then coming back to this, the pillars again, in this particular case, we really, again, tried, I think, made a very concerted effort to try to work on each one of these. Pillar policy, obviously, the case was seeking injunctive relief, but beyond that, it really, the work went both ways. We obviously were doing the work and trying to provide support to the community folks, but the community folks were really directly supporting the litigation in very concrete ways. They filed several amicus briefs at different junctures of the case, which were incredibly helpful. They were cited by the court in decisions, I think, at class certification, at the post-trial phase. They submitted a post-trial brief, and then also when we were in the Second Circuit trying to oppose a stay that the city was trying to get after we were victorious, there were, I think it's something like 37 declarations put in by community groups explaining why a stay would be disastrous. Unfortunately, Second Circuit didn't listen, but that's a whole other story. And then I think most importantly, the remedy which the court ordered after we went to trial and after we won, the remedy that the court ordered specifically carved out a role for community groups to give direct input into the reforms that the court would then order, which I can talk more about in the Q&A, but that was really something that we pushed very hard for, and I think if it wasn't for the involvement of these groups throughout the life of the case, I don't think the court would have been convinced that was a good idea, but because they had been so involved with filings, with coming to court literally every day for 9 weeks, we had a packed courtroom, that had an impression on the judge, and so she felt, I think, that it was really important to involve them in designing the remedy, which again, when you think about the Daniels case, is that didn't happen, and so that was very important to us. And then when we talk about, I think, the pillar of consciousness, really, I think there were really, two very important ways that we tried to move that forward. And one being, I think, the media strategy, right? And there were certain points in the case where, one being an op-ed, which I'm going to talk about in a second, but also in the way that we had not only our clients, but other impacted folks who were members or worked with the organizations that we worked with, being able to, have access to the press. But then also, I think the other way that we were able to do that in terms of the press was using the data, which I talked about earlier, to really change the narrative, because the narrative up to that point had been stop and frisk reduces crime, stop and frisk makes the city safe. And we were able to flip that because we were able to show, well, actually, it has a negligible, if any, impact on crime. And the flip side is that it's really having a harmful impact, particularly on people of color. It's discriminatory. It's not finding any guns. And so that data really, we were able to really shift the narrative in the way that the case and the issue was being covered. And then lastly, I think most powerfully, having our clients have the ability to go into a federal courtroom and in front of a federal judge to be able to tell their side of the story and to tell their experience about how they were treated by police is not something that people get to do very often. And to be able to do that over and over again in this very, publicized, high-profile trial was a very powerful thing, not only for them, but I think for the judge and for everybody watching and for the reporters who were there. And then lastly, in terms of the pillar of service, we were really able to provide some legal support to the legislative efforts that the coalition was working on. Here are some of our clients at the press conference the day that the judge issued her decision. Obviously very happy. But, again, this was the press that we did around this, we always tried to basically have them talk, and as lawyers, we were there to answer questions. If reporters had legal questions, but in terms of the affirmative narrative, we always had our clients being the ones to do that. And the op-ed I was talking about earlier, I feel like this was a game changer because it was 2011. It was kind of in the middle of the litigation. We had just got past summary judgment. The press was starting to pay attention to the issue again. And Nicholas Pert wrote this op-ed, which some of you may have read. It was in December of 2011, where he goes through kind of the 5 times he was stopped and the impact that had on him. And I think that was really the first time I had seen the really a first-person account of this in a mainstream media outlet. And after that, I think you really started to see the media coverage shift in a way that I think was more favorable for our side of the issue. There was a Father's Day march in 2012 that, we had 10,000 people marching down Fifth Avenue. Everybody probably knows the guy in the front there. He always seems to show up at these rallies, even if he didn't organize them. And as I mentioned earlier, which is good, he brings reporters. The trial, which was 9 weeks long, was an incredibly powerful experience, not only for me as a lawyer in terms of just the trial experience, but having a courtroom that literally every day was packed with folks from one or another of the communities that were directly impacted by this practice, whether it be, youth of color, homeless folks, public housing residents, street vendors, sex workers. Like every day there were people in the audience, full courtroom, watching this trial so that the judge could really see, how this was impacting New York City and the people who lived in New York City. And this is a quote I really think resonates with me too when we talk about the history piece again. This is direct testimony from David Floyd. And the reason I think this quote resonates with me is he's really talking about, right, his freedom of movement being restricted, right, by the police, by law enforcement, by the state. And for me, that really harkens back to the years after the Civil War when we talk about in the South, after Reconstruction, what the Southern states did with respect to, the vagrancy laws, the black codes. I mean, that was really about, right, there's the book Slavery by Another Name. It was really about restricting free black men and women's freedom of movement, right, and that their freedom of movement was going to still be under the control. I mean, they weren't going to have freedom of movement effectively because of these laws. And so, again, and the way those laws were enforced were by police, obviously. And so I think that is a place where, it was very powerful for him to say that. And when he said that, I think he was thinking about that because David himself, who's now actually, he's a doctor, he recently graduated from medical school, was very much a student of history, and that was why he got involved in the case himself, because he saw those connections. There's a picture of me with our client, Leroy Downs, from Staten Island, talking at the press conference. So I know we're running short on time, so I'm going to end with this and then open it for Q&A. This is a quote from the trial decision of the district judge, Shira Shinlin. And this is the part of her decision where she creates this process for directly impacted folks to give input into reforms. And I think, to me, this really, when we think about, as lawyers trying to use legal strategies to bring about, broad, fundamental change, I think this really captures what our approach to that has to be, which is that it's the directly impacted folks who are going to know better than any of the so-called experts, what the consequences of reforms are going to be or will be. And so their voice has to be really at the forefront of any discussions we have about, changing or ending some kind of illegal or discriminatory policy or practice. And so this judge recognized it to her tremendous credit. She paid a dear price for that. As many of you may know, after the decision came out, she was ultimately removed from the case under very shady circumstances, which I can talk about in the Q&A. But I think this quote really captures for me why we brought the case, what we were hoping to accomplish, and ultimately I think what we have accomplished in the case. So I'm going to end it there because I really would like to hear from you guys, and hopefully our discussion, I will be able to bring up a couple other points I had forgotten to make, but I don't want to talk anymore. So if anybody has any questions.
And when you ask your question, just introduce yourself and the year that you're in as well. Okay, well, I have a lot of... Okay, perfect. Okay.
Yes.
Hi, I'm Calypso. I'm a first-year student. I'm just interested in how, because obviously, like, when these decisions come down, the police don't actually change their practices; they just find ways to hide them. Mm-hmm. How do you work, I guess, with other, like, do you work with public defenders, or who do you work with to make sure that they're not continuing to get away with it?
So a couple of ways. One is, yes, we talk to the public defenders. We also talk to our grassroots partners who, their members are the ones who are still interacting with police on the street. There's also, in this particular situation, we have a court-appointed monitor who has a team, and he's, looking at several aspects of what the police are doing. He's not, obviously, to your point, going out on the street and seeing what they're doing there, but he's, reviewing their trainings. He's going to the precincts, he's talking to police officers, he's meeting with community groups, he's watching body camera videos, which we can talk about if you want. So he's also keeping an eye on the police department. But, you're absolutely right, because this is a great decision. The judge sets out a roadmap for how they're supposed to change, but that change has to be implemented. And, for the last 4 years, basically 3.5 years, our job has been to try to look at that. So I am doing almost as much work now as I was at the time of the trial, looking at that exact question.
And what have been the major challenges in that implementation and the monitoring process? And also, is it usual to have a court-appointed monitor, or is that quite a novel?
I mean, so yes and no. I think in the Department of Justice consent decrees, it's pretty common. Mm-hmm. In cases involving private plaintiffs, first of all, there's very few of those cases because a tremendous amount of resources, obviously, and then to actually win the case is also very rare. So for those reasons, it's rare to have a monitor. It's very hard because I think the police department, again, to your point, there's this decision handed down, but they disagree with it, right? They tried to appeal it at first. Ultimately, for political reasons, we had a change of mayoral administration. They dropped the appeal, but I think there were a lot of people in the police department that thought that was a betrayal. So there are still a lot of folks there who were there, from the prior administration who believed what they were doing was right. So in terms of the people who have to actually implement these changes on the ground, there's a little bit of resistance. So yeah, it's very challenging, and I think, ultimately what we want is culture change. In other words, a different approach to policing that doesn't reward, or that rewards fair policing, rewards treating people with respect, treating people fairly. And what we've had forever is police department that rewards aggressive, abusive policing, getting a lot of arrests, that kind of thing. So whether, if and when we can do that is still very much up in the air. Yes?
So I'm Daryl Miller, and I teach civil rights litigation here, and really appreciate you coming out. So one thing that I was interested in how you negotiate is your duties to the client, your duties to the community, and your duties to the movement. Because I can imagine many cases those things will not be aligned, and that there are, you know, letting the client just get in front of the cameras could actually be a high risk strategy. So how do you think about those kind of issues?
So we thought about them a lot. I think, a couple ways we tried to address that. I think first and foremost, when we were developing the case and trying to identify plaintiffs, is we spent a lot of time interviewing folks who were interested. I mean, we kind of put out a wide net. If you've ever been stopped and frisked in the last, 5 years, and you're Black or Latino, we'd love to talk to you. And then it was like, it's really sitting down with folks and saying, like, not because we were concerned that they wouldn't present well, but to say, like, why do you want to get involved in this case? Is it because you want money? Because if that's it, then you should file an individual in 1983. But like, this case is about systemic change. So first, finding people who kind of shared those values, and then all of our clients did extensive media training with our communications folks, and it definitely paid off. I mean, our youngest plaintiff, David Auerlicht, was, I think, a college student at the time, and he had a learning disability and was very nervous about public speaking. I mean, he ended up I think the week before trial, he was on NPR, like for an extended interview on the national NPR, and just killed it, But that took several years. And then, but in terms of obviously our obligation ethically is always first and foremost to our clients. And so the one point where that became not an issue, but something that we definitely had to navigate was, we didn't bring any damage claims for the class as a whole. We just brought an injunctive relief class. But for the individual plaintiffs, we did have damage claims. Now, for 3 of the 4, their damages were going to be negligible because, they had been stopped, but it wasn't like they were arrested or there was no force involved. So they weren't really looking at much money anyway. So, but there came a point in time where we were like, I think the best chance we have of winning this case is if this is a case tried to the judge and not to a jury, because a federal court jury in Manhattan, you're going to get mostly people from Westchester. It's just not going to be a good jury for you. And really the issues were so complicated, particularly the statistical issues, we felt we needed to have this as a bench trial. But the only way we could do that is if we gave up our damage claims. And so for 3 of the 4, they were like, well, yeah, that's fine. I never really cared about that anyway. The 4th gentleman, Dion Dennis, he had been arrested and held overnight, and so he, could potentially, and we met with him, and we didn't have it, like literally after we presented, here's the situation, he said, yeah, that's fine, I'll, we're like, are you sure, because and he was like, no, I didn't bring this case for the money, I didn't want this to happen to me, my son, I don't want this to happen to us anymore, so if you think this, and so that was it ended up being very easy, but I think that speaks to, like, we had great plaintiffs who really were doing this for, similar reasons as us. Let's see, I'm going to go there and then come here since we just did one over here.
Kind of a follow-up. I'm Gabrielle, I'm a 2L. A follow-up on the plaintiffs and how you choose which plaintiffs are your named plaintiffs, and more specifically, how do you make sure the plaintiffs you're putting before the media are representative of the entire class? Because I did notice that some of the pictures were all men.
Yes. So we ended up, so those were the 4 named plaintiffs. We did have, when it came time to trial, we had 13 witnesses, so the 4 named plaintiffs and 9 class member witnesses testify, only one of whom was a woman. We did speak to many, many women, and actually there were several who, obviously women were illegally stopped too. There were several who I think would have been very compelling, but interestingly, a lot of them involved what I would classify as like kind of, there were definitely some things that were done during those stops which I think bordered on sexual assault, and I think they were very uncomfortable talking about it, because it's because you have to get deposed, you have to not only testify in court, you have to get deposed, which is a miserable experience for anyone who's been deposed. And so ultimately they decided not to do it. The one woman who did, she did a great job, but even at like the way she was cross-examined, like I feel like the city attorney was trying to suggest very indirectly that she was a prostitute, because he's like, so what were you wearing when you were walking down this, deserted street? And, it was just really yucky. So, it's definitely something we're cognizant of, and we tried to bring more women in as plaintiffs, but it was very challenging to do that. Okay, you both have, so I'm going to do this gentleman and then...
My question was kind of on Professor Miller's question. I know that during integration, when they're fighting segregation, a lot of states or schools would try to kind of buy off the named plaintiffs. I'm just curious if that was an issue in your case.
Yeah, I mean, fortunately for us at that time in New York, the city attorney's office was very unwilling to do that. In a lot of cases, they would make these very nuisance settlement offers of $5,000. So it was very easy to reject. Now I think they're a little more strategic from what I understand. But yeah, back then they were just like, this case has no merit. We're never gonna, make you a real offer. So we fortunately didn't have to deal with that. Yes.
I was really interested in what you said about this kind of participatory remedial process, and I'm wondering if you could give some kind of more examples of what that looks like in other issues, and if it switches from prevention to accountability to what the sphere looks like.
So in terms of other examples, when we were doing the research, because we proposed this to the judge, and we did research, and where we saw it, I guess most often, I mean, it's not very common at all, is I've seen it in the housing discrimination context, actually, which is interesting. What's the big case in Baltimore? The Thompson case, which I think is now maybe 20 years old, but that's a huge case that the NAACP Legal Defense Fund brought, and I believe they had something kind of analogous to this, where the tenants themselves there was a process for them to have input into how the housing situation was going to change. In terms of law enforcement, policing, the example we drew from most was Cincinnati. So I don't know if you guys are familiar with the Cincinnati, they call it the collaborative, but basically in the early 2000s, there was a similar case, a racial profiling case brought against the Cincinnati Police Department by the ACLU of Ohio and a Black United Front, which was a local racial justice organization there. And in that case, it ended up settling, but the settlement created this, what's called the collaborative agreement, which was developed through a very similar process where over a course of, I think, about a year, they got input from, I think it was 8 different kind of stakeholder groups in the city around policing, and developed the remedies through that. So that was really, we talked a lot to the lawyers from that case, and as well as the Black United Front leaders, just to pick their brain about how to do that. And so that was really probably our biggest inspiration. Yes.
Hi. When you talked about that it was a very deliberate decision to do more outreach to sort of grassroots communities and affected communities throughout the course of the case, I'm wondering if you could say a little bit more about what those strategies were, and also if it's something that CCR has tried to replicate in other types of litigation.
We definitely have tried with varying levels of degree to replicate or to do it in other litigation, which I can talk a little bit about. The strategies we use is really, I think trying to take advantage of the relationships that either we as individuals had with some of these groups, because a lot of folks at CCR, I think, outside of our jobs have our own kind of political activism, but then also, just talking to allies and trying to develop the relationships organically. It wasn't like we would cold call some hey, let's call the National Congress for Puerto Rican Rights and see if they're interested in this issue. It was, we've been working with them going back, decades. It's a much easier natural conversation to have. And frankly, in the Daniels situation, they came to us, and I think it was because our executive director at the time, Ron Daniels, no relation to the Daniels in the case, had been working in that movement, since the 70s, really. So, I think the lesson for us is relationship building is as important, I think, as our legal work, because if you don't have the good, strong, trusting relationships, the directly impacted folks are not going to bring the issues to you. They're going to look somewhere else, and then it's like then it's not really the kind of case we want to do if it's not something that the directly impacted community thinks is a priority. We're not going to make it a priority just because we think it is. Did somebody else? Yes.
Hi, I'm Pierre-Philippe. I'm an LLM. I'd like to know, because you mentioned that you have a communication team that trains the plaintiffs, but I wanted to know more on the psychological aspect. How do you train them during and, most importantly, after the cases take place? Because I imagine they're subject to intense scrutiny.
That was a very difficult process, in terms of, so for example, I think the depositions were probably the most stressful, more stressful than the trial, because trial, you have a judge who can rein in a overly aggressive, opposing counsel. In a deposition, it's just you, your client, the lawyer from the other side, and a court reporter in a windowless conference room usually, and that they can ask them almost anything, and it goes on for 7 hours. And none of our clients had ever been deposed before, so we prepped them. We did kind of mock cross-examination, but there was really no way to completely prep them for that. I think it was just really during it, sitting next to them, not only as their lawyer, but like kind of as a friend, to say, look, I'm here. I am here to, in some ways, protect you and make sure you're okay, right? So a lot of breaks to just say, are you okay? Like, you're doing great, just answer the question. If you don't know the answer, the best answer is, I don't know, and they all did incredibly well. And I think at one point, this is a funny story from the deposition. It was on the record, so I'm allowed to say it. I'm not revealing comments. One of our clients was being deposed, and he was just doing such a great job. The city lawyer would ask the question, and he would pause and make sure he understood the question and think about it and kind of go like this. And then if he knew the answer, he'd give it. If he's like, I don't remember, or I don't understand your question, and the lawyer was getting so frustrated, he basically, he accused me on the record of coaching him, which I was like, I'm not, And to me, that just showed that the client was doing such a great job of just being like, yeah, I'm taking my time, I'm answering the question that's asked. If I don't understand it, I ask him, I tell him I don't understand it. If I don't remember, he's not. Because I feel like the natural tendency for a lot of, most people is you want to, if someone's asking you questions, you want to give them an answer. And so you sometimes will be giving them information they either didn't ask you for, and you're making their job easier. If they ask a confusing question, say, I don't understand, So it was hard. And all of them, I think, were exhausted by the end.
A question about Backlash,
Yes.
in particular, thinking about human rights lawyering and advocacy. We're challenging structural racism, sexism, different inequalities.
Mm-hmm.
And if you have any sort of modicum of success in that context, you're going to have backlash. And often we plan for that as part of our advocacy strategies, and we're thinking through short-term and long-term outcomes of a particular engagement strategy. What was the backlash that you experienced in this context, including you mentioned that the judge's removal as one example, and how have you sought to mitigate that backlash?
So the backlash, the biggest backlash we got, which we kind of had a feeling would happen, but we just didn't know how to prepare for it, was from the police unions, actually.
Mm-hmm. Yeah.
They were incredibly aggressive and hostile and just nasty. As soon as the decision, they had stayed quiet for 5 years. The litigation went on for 5. They stayed quiet, and then I think it was it was interesting. It was, I think, literally the day after. So this is where the politics, I think I mentioned earlier, it's interesting. So we get this decision in August of 2013 from the court saying, they violated the Constitution. They have to do all these things to change it, right? City, that was still Bloomberg administration, Ray Kelly administration, they immediately file a notice of appeal. Meanwhile, we have a mayoral election that's going on at literally the same time, and it's the Democratic primary is coming up the first week of September. And 4 of the 5 Democratic candidates, seeing the way the winds are blowing, are like, if I get elected, I'm going to drop this appeal, right? They all say it, right? This is stop and frisk is terrible. We shouldn't do it anymore. And if I get elected, I'm dropping it. So then the election, I think it's like September 7th or something, Bill de Blasio wins the primary, which in New York at this point, because of who was running on the other side, that was effectively he was going to be the mayor. And so then 4 days later, the police unions move to intervene in the case. And they say, we are moving to intervene because we know that the city is no longer has our back because the next mayor is going to drop the appeal. And so because of that intervention, the case literally is held up for the next year in litigation, because even when de Blasio gets elected and decides to drop the appeal, and there's a big press conference, and Vince, my boss, goes to the press conference and stands next to de Blasio and says, we're dropping the appeal, it doesn't matter because the unions are in court now saying, we're going to take this appeal up if the city doesn't. And so we ended up having to go all the way to the Second Circuit on the issue of intervention, not even on the merits of the case. And ultimately, the Second Circuit says, you have no standing, get out of here. So we were okay, but that we were not prepared for. And then similarly, along with that is because not only were they doing that, they were really had this huge misinformation campaign amongst the rank and file, so that everyday police officers were like, oh, well, now I can't stop anybody anymore because I'm going to get sued, or, you know, these lawyers want me to get killed. And like, it was just really nasty. We weren't really anticipating that.
I have another question. I'm
Sure.
going to give a chance to everyone else's questions to come to the surface. I mean, you mentioned a couple of times the importance of messaging, which changing the narrative was the terminology that you used, and we talk a lot about in the clinic and in the advanced clinic and in our seminar about the need for messaging around human rights, right? That it's not enough to do litigation, to do social movements. You need something else. Can you talk through how that takes place in an organization like CCR?
Well, you know, as I alluded to earlier, we have a very amazing communications department. Folks who, I think our current director actually won a Pulitzer Prize when she worked for the New York Star Ledger. So we have really smart people, first of all. But again, I mean, it goes back to talking to our grassroots partners. Like, you know, how do you want to tell this story? Because that's the changing the narrative is not only the content of the narrative itself, but who's putting it out there, right? And so we always wanted it to be the directly impacted folks, because, you know, the way the issue was really talked about up until probably 2011, until Nicholas's op-ed, was like you had, you know, policy people and government officials and police officials and civil rights lawyers having the discussion, but the people who were being stopped and frisked were not part of that discussion. And so I think that was the main thing. It's like, so how do you guys, and for them it was like always like, we want to talk about this as a racial justice issue. Yes, it's a civil liberties issue, but it's really for us a racial justice issue. This is about discrimination. It's about racist policing, and that's how we want to talk about it. You know, which I think then the way that ties into the legal case is like, okay, so we're bringing a Fourth Amendment claim, but we're also going to do the equal protection because that's really for us and for what the community, that's really the heart of the problem for them. Yes.
Hi, I'm Chelsea. I'm a first-year student. I was just wondering about that op-ed, how that came about, whether it was his idea or your communications team, and how the New York Times responded.
So it was, how did that come about? So it was interesting. So we pitched, I think we originally pitched an idea, we hadn't chosen which plaintiff was going to do it, but we pitched the idea to like a bunch of the newspapers like in early 2011, and there was not really any interest. And then, you know, in August of 2011, the judge actually issues a very good decision, which if there was no trial decision, this would have been kind of her landmark decision, which was denying the city's summary judgment motion. And she really kind of lays out, because that was the first time that we had really put all the evidence from discovery in front of her. And so that was the first time the media had seen like these deposition transcripts and seen these stop and frisk forms and seen the data, and they were like, whoa. So there was very good media coverage of that decision. And then I think actually Michelle Alexander read the media coverage of it. And she reached out to my colleague Sunita Patel, who's now a law professor at UCLA. You guys may know her, but she was my co-counsel on the case at the time, and said, I really think you guys should have one of your clients do an op-ed. And we're like, oh yeah, that's a great idea. We never thought of that. And we were like, could you help? And so she kind of helped get the New York Times to accept it. So it's really Michelle Alexander gets all the credit.
So one more question, I think we may be out of time. Okay. At the beginning of your presentation, you described yourself as a civil rights and then you went human rights lawyer.
Yes.
And I think what's always struck me, early in my career, I was part of a co-counsel group with CCR working on, we were suing the US government for information about the CIA's rendition attention interrogation program. And part of the reason why we partnered with CCR was because even though it was a very American organization in many ways, it did take a bringing human rights home approach. It also engaged in litigation abroad, for example. Can you talk a little bit about what it means to be a lawyer in an institution that does have that bringing human rights home approach? How does it change your work?
Well, I think one way is what I alluded to at the very beginning, which was, that for us, the work is really, it's guided by what the people on the ground are experiencing, as opposed to this is an issue that we think is important. And I'm not saying that other legal organizations don't do it the same way that we do, but I think that's part of when we talk about human rights and that for us it really comes down to what are people experiencing, what injustices are they suffering, what do they want to see change. And then similarly, I think, and I know this is a cheesy way to talk about it, but speaking truth to power, in other words, really not trying to sugarcoat the way that we frame a legal case or an advocacy project, really talking about what it's really about, and so in this example, it's this is really about racism. And the Guantanamo situation, it was very much about these people are being tortured, they're and so there was a rule of law aspect to it, but it was also no, they're being tortured, right? And in almost any of our cases, I think that's really the guiding principle, is we're going to really speak truthfully about what this case is about and what's really going on here, because that's what our clients want, that's what the movement wants, even if it's not necessarily going to be fit nicely into a legal claim, because obviously a lot of times it doesn't. And in this case, we were mocked by some of our colleagues in the civil rights community who will remain nameless. You're bringing an equal protection claim, you're never going to win it. That was literally what they said. They're well, maybe we won't, but the point is that's what the case is about. So why we have to include that? That has to be in the case. So.
Okay, well, thank you very much.
Thank you.